All right, so in the matter of the people of the state of Michigan versus Caitlin Elizabeth Whiteman, file number 21-20579FH, I have Matthew Murphy appearing on behalf of Ms. Whiteman, and this was supposed to be the date and time set for sentencing. I have a pre-sentence case report provided to the court that said Ms. Whiteman pled guilty to count 2 weapons, taser possession or sale on December 27th of 2023. Sentencing was scheduled for February 2nd of 24. Ms. Whiteman provided the wrong number to Agent Jones at the time of her plea, and this agent emailed Mr. Murphy on the same date to see if he had another number. The agent called the other number, left a message, texted it several times. She did call back on January 3rd. They set up a time on January 8th to meet, and she said she wasn't able to leave. There was a mix-up in vehicles, and she would just be delayed, and she's never showed up, text or anything else. Is this yours, Ms. Walsh?
Yes.
All right. So, Mr. Murphy, have you heard from her?
I have not, Your Honor. I do apologize for her absence today.
Well, it's not your fault.
Have any more information?
You always show up. So I am going to issue a bench warrant for her arrest, and I will set bond in the amount of $50,000 cash.
Yes, Your Honor. Thank you.
You're welcome.
Have a good morning. Thank you.
You too. Thank you, Mr. Murphy. I don't know where Mr. Dagger Margosian is though. All right, Mr. Malaro has not logged in. Will you go see that?
He's having trouble out there.
Becky, can someone go help Mr. Malaro log in onto the Zoom device?
Yes.
And Mr. Love, we apologize. You were supposed to be here back on the 2nd, but we weren't able to get you zoomed in because the MDOC wasn't available. So we apologize for that.
Oh, it's okay, thank you.
All right, I have someone who's called in on an iPhone. Can I ask you to unmute and start your video, please? It's I was sending people out to help you, Mr. Malaro. All right, so Mr. Love, I'm going to open up a breakout room, and I'm going to put you and Mr. Malaro into that breakout room. Really highlights your beard on that iPhone there, Mr. Malaro. So you're welcome. All right, so Mr. Love and Mr. Malaro, go ahead and join that breakout room. Every time my husband and all the boys are together, because you know we have a ton of boys, they all have beards, and it's like being back in the 1800s. Well, they all have beards except one because he can't grow one. But
Is DOC here for Wilson?
I'm sorry,
Is DOC here for Wilson?
Far they haven't showed up yet.
not yet.
Oh, really?
We don't have fingerprints on him.
Yeah.
Yeah, I see that. So I got something over there. So I'm close by.
All right,
I'll keep bouncing.
okay. Sorry, Mr. Malaro. Okay, I'm gonna close the breakout room.
I just wish I could make my beard darker.
It's called Hair for Men.
Well, I meant on the Zoom. Too vain for that.
Too vain. That's fine. All right, so we're back on the record with Mr. Love. So Mr. Love, have you now had an opportunity to speak with your attorney?
Yes, Your Honor.
All right, are you satisfied with Mr. Malaro as your attorney and the advice that he has given you?
Yes, Your Honor.
All right, Mr. Malaro, do you wish to explain or challenge the accuracy or relevancy of any of the information in the pre-sentence report?
I do not, Your Honor.
All right, before, does the pre-sentence report disclose any prior convictions in which there exists any known constitutional defect?
Not to my knowledge, Judge.
All right, before the court passes sentence, is there anything you'd like to say on behalf of Mr. Love?
Judge, I've known Mr. Love actually for quite a while now. Seems to be a pleasant young man. You know, he's in prison on another matter. But I think Mr. Love has realized that in order to be a productive member of society, he has to take responsibility for his actions and then strive to live a law-abiding, productive life. This happened prior to him going to prison. And so I think the recommendation is appropriate. We'd ask the court to follow it. And I actually have confidence that Mr. Love, when he is released next year, will become a productive member of society. Thank you.
All right, Mr. Love, anything you want to say on your own behalf?
Yes, I want to thank Mr. Malero for being my attorney and guiding me through the process. And he's a great counsel, and I appreciate him so much.
We're recording.
Thank you.
Yeah, we're recording that, Mr. Malaro. All right, well, thank you, Mr. Love. In determining the appropriate sentence in this case, the court has considered the seriousness of the offense, your history, the principle of proportionality, the statutory penalty, the cost of confinement, a sentencing guidelines which did not apply, the report and recommendation of the probation department, and what has been set upon the record at this hearing. The criteria and reasons for the sentence are the nature and gravity of the offense, the discipline appropriate to its commission, deterrence against repetition by you and by others, the potential for reformation, vindication for the law, and the protection of society. Sentence of the court that you will serve 1 year or 365 days incarceration, and that will be concurrent with the Michigan Department of Corrections. And they say with credit for time served, and of course, they have not provided that to me. So let me go back. I'm gonna look back. Do you have any information in your file when he was arraigned?
Yeah, I'm looking it up now, Judge. His arraignment was July 7th of last year.
So, you'll see
That's
it.
6, that's 180 days, plus another, let's say 9th,
9, so another 32 days.
189, and then another 24. What did I say, 189, 24? So that's 213.
All right, so I'll give you credit for 213 days, Mr. Love. And Mr. Love, I hope that when you get out, you make those changes, because I believe that you're capable of doing it. And so I wish you the best of luck. So there will be no probation, but there is a $68 state cost for each count and $130 crime victims' right fee.
Judge, sorry.
Yes.
I think those are
Oh, it's
misdemeanors.
misdemeanor. So it'd be state costs in the amount of $50 per count. And then there is a crime victim rights fee in the amount of $75. And I give you 365 with credit for 213 and no probation. So we are going to mail to you your appellate paperwork, and you do have a right to appeal this sentence. And then when you get it, there's going to be 3 copies, and one is to be signed by you and dated, and the other 2 are for you. If you wish to appeal your sentence, you would fill out the form and mail it to the address listed on the form within 42 days, okay? And they just have you initial and date 1 copy to come back to me, just so I know you got it, all right?
All right.
All right, good luck to you, Mr. Love.
All right, thank you, Your Honor. Appreciate it.
Thank you.
Good luck, Terrell.
All right, thank you, Malero. Appreciate you. Thank
For the
you.
record, did not put any money on his books for that comment.
Okay. Bye.
All right.
Isn't he a twin?
Yeah,
I have a story about him and his brother from like 10 years ago. I'll tell you off the record.
feel bad for him because
Huh?
dad's a tool.
Well, we're on YouTube. So, all right, so I have Mr. Voss. No.
Yes, Mr.
Yes.
Voss.
Are you ready or you need to talk to him?
No, we're ready, Judge,
Okay.
but may I approach on some documents, I think would help the court.
Okay, so Mr. Moore, are you on this one? You can come up to the podium, Mr. Voss. You can come up.
Yes.
I talked to Mr. Moore about these yesterday, but I thought you don't be here, I was gonna show it to him. Some of it is reflected in the PSI, Judge. Deals with treatment and then some
All right, I'll put him
medical.
on the script. Okay. All right, this is in the matter of the people of the state of Michigan versus Benjamin Raymond Edward Voss, file number 2023-21387FH, as Salvatore Malaro appearing on behalf of Mr. Voss, who is present in person. Mr. Malaro has handed to me July 16th of 23 letter from Sacred Heart verifying that he was admitted and discharged and completed the program. And then I have another one of July 16th of 23, which is a letter by Dr. Romanek. I don't know what this one is.
What is it, Judge?
Well, it's a letter, it says, "Dear Doctor," and then it's signed Dr. Janice Romanek.
Oh, I think it's a return to work letter, Judge.
Why would, okay,
I
okay.
think it just.
No, it was just like abstain from all mood altering drugs, and I can't receive any, I think it's just a poorly typed letter. I think it's a letter from a doctor to another doctor saying that he can't be given,
Oh, right, yes, that's
Yeah.
letter, yes, sorry, Judge.
but, okay, and then I have Zep, how do you pronounce that?
Zap.
Yeah, Zep Center. Regarding Mr. Voss, confirming Mr. Voss participated in outpatient treatment. And this is dated January 10. He started treatment on December 11, and we meet Monday and Wednesdays for group therapy as well as bi-weekly individualized sessions. And he has verbalized change to desire to change his lifestyle, so he's compliant with that. And then there is spine fracture care instructions. Looks like a work excuse or an excuse for something for a dental appointment, and an order requisition for Mercy St. Charles Orthopedics, Mercy Mommy Bay. Okay, so I've got all those, Mr. Moore, so everything indicates he's doing what he should be doing. Any other information regarding that, Mr. Moore?
No, like I tell every client when they come in to provide me with that information as we go, so I can provide it to the court. And he can continue to provide that to me while he's on probation.
Yep. All right, so Mr. Voss, Mr. Malaro is filling in today for Miss Underwood. Both of them are excellent attorneys, but have you had a chance to speak with Mr. Malaro?
Yes, I did yesterday.
All right, and did you had an opportunity to discuss the pre-sentence report and read and review it?
Yes, we did.
All right, are you satisfied with both Miss Underwood and Mr. Malaro as your attorneys?
Yes, I am.
Okay, good. Mr. Malaro, do you wish to explain or challenge the accuracy or relevancy of any information in the pre-sentence report?
We do, Your Honor. They're like technical corrections.
Okay,
Mr. Voss is employed at Elmer Gooby, which is, I think, a construction company. He is on medical leave. If he retains full health recovery, he, I think, at least for income purposes, until he could find something better, tends to go back there. So I would ask that the personal history reflect that he is employed at Elmer Gooby. Second, with respect to substance abuse history, Mr. Voss denies the use of LSD and instead wants it to accurately reflect that he used acid, which may or may not be the same thing.
that's not.
Well, he doesn't use LSD. He did use acid in the past.
Okay, so we'll make that change.
Again, this is a technical thing on page 1 of the evaluation plan. Mr. Voss, would like, his, last name correctly spelled.
Hold on, I'm looking, oh, Bose, in the second paragraph, it says Bose.
Yes.
Okay,
And then, with respect to where his father worked, this is probably when you start typing, the computer decides what you're typing instead of you. His father did not work at Budweiser. He worked at Bud Company, BUDD, which I think is a trucking company. Is that true?
That was a glass company in Clinton years ago.
oh, okay, all right, Mr. Moore, you can make that change.
And then there was, so Mr. Voss and I had a very extensive conversation about the PSI judge with respect to his prior history. I actually called an attorney that's actively practicing, because I haven't been down there in a few years in Ohio. But it says on number 8 of 17, it says out of Lima Municipal Court, he was operating a vehicle impaired. I went and looked on his history there. There is no, that reflects this date and that offense. There is no impaired statute in Ohio. So I don't know if this is some kind of mistake, but we couldn't even find, and even when I called Mr. Deck, we couldn't even find a date that corresponded with this charge. So we'd ask that that be redacted.
All right, Mr. Moore, do you know where you got that?
Yes, provided by the prosecutor's office, which is unfortunate, you know, I can pull that out, and it may be that the operating under impaired had a different verbiage, but I will pull that out and confirm it, because we had added some things here that the prosecutor provided for me. The other thing is, but I just wanted to back up on the employment. We don't add employment if you don't provide proof, and to put that in the report would be inaccurate. But on that 8 of 17, I will pull up, look it up, find out exactly where I got that from, because I would have received that from the prosecutor's office, and see why it would be inaccurate.
So you look into that. And I misspoke. LSD and acid evidently are the same thing. It's just different forms.
Correct.
Okay,
But
so you were right.
we wanted some accuracy.
Okay.
Judge, on page 9 of this prior history, it seems to me that 14 of 17 and 15 of 17 are duplicates.
Correct.
They're the same dates and same everything. And then 16 of 17 also appears to be the duplicate of 13 of 17. Those seem to be the same dates and the same
Mr. Moore?
cases.
Yeah, let me take a look. This was, you know, unfortunately, we have a new program here, and this has been
Yeah, I know.
tricky. All right, hold on.
I know. Ms.
So-
Adams, you need that red book back. It's in.
It's the Rutherford County, Tennessee case, Mr. Moore.
Yeah, I'm looking here. 220, 13. Okay. All right, I'll eliminate it.
All right. I know I struggle with the new PSI program because I can never find stuff, but I'm getting used to it. So,
Judge, if I may, can I get it? So I don't know that this changes it doesn't change his guidelines. I don't doubt it. I don't think it changes the recommendation much, if at all. So that's where we stand. Just clarifications.
okay. So, Mr. Moore, when you go through that, you'll make sure that doesn't, if there's a change in guidelines.
Correct. Yeah, I'll make sure we go through and I don't have anything counted extra and make any, or that there's any changes there, but I don't believe there was.
Okay, and let's see, his guidelines calculated 10 to 23, Mr. Miller.
We agree with that.
Okay, all right, so, good. We went through convictions, went through accuracy, went through guidelines. So, Mr. Malaro, is there anything you'd like to say on behalf of Mr. Voss?
I would, Judge. I contacted Mr. Voss because I was covering this for Miss Underwood. He came in immediately to my office. We spent probably an hour and a half going over everything. I spoke to Mr. Coast. To see how he was doing, because I think he's doing twice a day PPTs. Yeah. He said he's been doing excellent, and this, I think, since June. So what's that, 7 months? So I think that speaks well of Mr. Voss's commitment to sobriety. I think the court has some documentation that he has sought medical help with this regard, and to the point where the doctors do not want him even taking medications that may affect his ability. That being said, Judge, and we had a very interesting conversation. Mr. Voss has a long history of alcohol abuse. Some people, it takes longer than others to recognize the problem, but Mr. Voss does recognize the problem. And I think since this has happened back in June, he has taken some very serious proactive steps to address the problem. He's been in rehab. He's under continuing care. He's complied with court orders. He has shown up, as far as I know, and looked at Ms. Underwood's notes. There's no indication that he didn't show for court at all. He's been totally compliant based on about an hour and a half that I've spent with him. I am impressed that he is totally committed to maintaining sobriety and getting this behind him. He also has a lot of medical issues that require attention. Judge, he understands that this isn't going to be a, hey, Mr. Voss, we're sorry all this happened to you, go have a nice day. He understands there's going to be an incarceration portion to this sentence. And I think that given his efforts put into maintaining sobriety and compliance with court orders, the recommendation is more than appropriate of 30 days. However, Mr. Voss would ask the court for one indulgence, and that is if the court's going to impose a 30-day or a longer sentence of continuous incarceration, that he be allowed a brief period of time, perhaps 2 weeks or so, to make sure that he doesn't lose his house for which he's renting, and make sure he gets his medical situation structured so that he can not lose any benefits he's obtained so far to the end. The only other thing I would say, Judge, is that when he was in my office, he did do one benefit for me. And that was he spilled his coffee all over, but he made my office smell better. So we'd ask the court to take that all into consideration when fashioning a sentence.
Hi, Darren. This is Judge Anzalone. I am on the record with Benjamin Voss.
Yes, Judge.
And you supervised his pretrial services, correct?
Correct. Right now, he's on the remote route.
Okay, and how has he done, I know you spoke to Mr. Malaro, but I just wanted it on the record.
Yep, no, he's done excellent. I've received 0 violations.
All right, very good. Thank you, Mr.
Thank you,
Coast.
Judge. Bye.
Anything you want to say on your own behalf?
Thank you, Your Honor.
Okay. So, Mr. Voss, as Mr. Malaro said, you have quite the record, which indicates that you do have an alcohol problem. And you also have some pain management issues, and sometimes those don't work well together, right? So, in determining the appropriate sentence in this case, the court has considered the seriousness of the offense, your history, the principle of proportionality, the statutory penalty, the cost of confinement, sentencing guidelines, the report and recommendation of the probation department, as well as what has been said upon the record at this hearing. The criteria and reasons for the sentence are the nature and gravity of the offense, the discipline appropriate to its commission, deterrence against repetition by you and by others, the potential for reformation, vindication for the law, and the protection of society. So had someone been injured or had there been a car accident, we would be in a very different situation today. Because if someone had died, you would be going to prison for a long, long time. But this was a driveway situation and unfortunately, no one was injured. There was no high-speed chase, no alcohol was involved. So the sentence of the court is that you will serve 30 days in Lenawee County Jail. I'm going to order that you serve 3 days consecutively now with credit for 1 day already served. And that I'm going to suspend the balance of the 30 days. So when would be a good time to schedule your 48 hours in Lenawee County Jail? Want to do it this weekend?
Can I do that next weekend, please?
Okay.
Report on Friday night.
All right, Mr. Moore, do you know what the report time is at the jail for weekends?
I don't, Your Honor.
Okay, do you work next Friday?
No, that's why I need to schedule it off.
Okay, all right, so, what time you get out of work?
I can be there anytime on Friday.
Anytime on Friday? So, I don't know when's the best time to report to the jail, so let me ask. No,
Not at noon.
not at noon. They don't even like me to call at noon. Hi, this is Jen Anzalone. I have a question for you. I have a gentleman that I'm ordering serve 48 hours in Lenawee County Jail. And I need to give him a time to report on a Friday. Do you know what's a good time to tell someone to report on a Friday?
Well, usually probably after everybody's done with court, but if he's reporting to jail for 48 hours, we should be able to handle him pretty much any time.
Okay, all right. So, all right, thank you.
Yes, ma'am.
Bye-bye.
Bye-bye.
So why don't we say 10 a.m.?
That'll work.
That way I know you'll get out before the end of the day on Sunday?
Yep.
Okay, so I'm gonna order that you report to the Lenawee County Jail on, that would be February 16 at 10 a.m. You'll serve 48 hours in the Lenawee County Jail. So I'm ordering 3 days, giving credit for 1, so you're gonna serve 2, okay?
Okay.
And it'll be a 48-hour sentence, so there won't be any good time on that. You're just gonna do 48 hours, okay? And I am going to place you on probation for a period of 3 years. I'm gonna suspend the balance of the 30 days. You will complete 30 hours. Or let's see, let's do, what's a statute? Hold on. I'm gonna do 120 hours community service. So that's like 40 hours a year, okay? And $750 in court costs. There's $500 in penal fines, $210 OUIL reimbursement fee, $130 crime victim rights fee, $68 in state costs. Do I need a DNA fee, or we already have a DNA fee on them?
I don't have a DNA fee on it.
Say that again.
We need a DNA fee.
All right, DNA fee of $60. There's $30 per month supervision fee, $60 if you're placed on a tether, and then there is a $450 court-appointed attorney fee. So these offenses are incredibly expensive. During your term of probation, you're not to violate any criminal laws. You're not to leave the state without consent. Do you work in Ohio?
I live in Ohio.
Okay, so he lives in Ohio. Do you travel for work
Yes, I do.
out of Ohio or Michigan?
Actually, currently, right now, I'm living in Ohio and I'm working in Ohio.
Okay, so Mr. Moore,
So what's gonna have to happen, he'll come see me Tuesday. will have to put an interstate transfer in. He'll be supervised out of Ohio. It's going to cost him $200. He'll need to bring that Tuesday. And we'll place that, we'll start the transfer immediately.
So because you live in, is that where you permanently live, is Ohio? So it's $200 to transfer your probation to Ohio. So next Tuesday, you need to bring $200 to pay for that. And when you meet with Mr. Moore next Tuesday, they'll do the paperwork to transfer you to Ohio, so you can report there and do all your stuff there. All right. All right, you are not to use, possess any alcohol, beverages, or other intoxicants. Can't go into bars, other places where the primary purpose is to serve alcohol, unless you work there and you get permission. You must comply with all the requirements of alcohol testing that might put you on different tethers for alcohol if they have any concerns. You must comply with the requirements of drug testing. So you're not to use any illegal controlled substances. Okay, and I say illegal because I know marijuana is like, I think it's legal in Ohio now, isn't it?
Sort of,
Huh?
sort of illegal.
Recreational.
All right, so you're not to use any illegal controlled substances and test as required. Complete a substance abuse assessment, which we probably have a current one, but if they need one at a later date, must report to probation monthly or as often as required. You must complete any recommended treatment that they provide or ask you to do. And as I said, I took the community service down to 120 hours. Report any change of address or any change in employment. They can enter your home at any time. They can look at your car, your phone, your person, understand not to have alcohol in the home. So there's no alcohol in the home. All right. And you can't drive. You don't have a driver's license, right?
Right.
All right, you can't drive. So if you drive, and you get a ticket for driving with license suspended, that could be a violation of probation.
Right.
And it's hard, I know. I mean, it's hard to live without driving. Let's see, I did all of that. All right, anything else, Mr. Moore?
It just, he needs to see me next Tuesday at 1 o'clock.
Okay. You just want clarification, he's required to stay on the PBTs till he reports to jail?
No. You want the PBTs for this week until he reports to you Tuesday?
No, that's those are bond conditions, Your Honor. So those would cease. That's fine.
Stay on that. Okay, sorry. Oh, he doesn't have to do that.
No, he doesn't have to do those anymore. So Mr. Voss, you're done with your bond conditions because you're being fined, okay? So my bailiff is going to hand down to you 3 copies of your notice of right to appellate review. I need you to sign, initial and date 1 copy for my records to acknowledge you received it. The other 2 copies are for you. If you wish to appeal your sentence, you would fill out the information on the form and mail them to the address listed on the form within 42 days.
Days of 9? Yes.
Mhm.
I know days is.
All right, so, do you need him to stop across the hall at all today, Mr. Moore?
No, Your Honor.
What time Tuesday?
1 p.m.
1 p.m.
Next Tuesday, all right?
Okay.
Mr. Voss, I wish you the best of luck.
Paperwork or anything before I leave?
No, just be back here next Tuesday to meet with Mr. Moore.
Thank you, ma'am.
Thank you, good luck to you
I
both.
did have one other question before I leave. That 30 days, is that still part of the sentence?
Suspended.
So I suspended it, so I ordered that you serve basically 72 hours in jail, and I gave you credit for 24, but you have to do the full 48 hours.
Right, that's.
And then if you violate, serve the 30 plus whatever I give you.
Okay,
All right, so keep up the good work.
thank you, ma'am.
All right,
Thank you.
thank you both. Have a good day.
God bless y'all.
Thank you.
guys.
No, I know, yeah.
All right.
You told me that a minute ago, didn't you?
Yeah, that's checking.
What you doing?
I was hoping we could talk about Jeremy Sneed. We have a final pretrial on Wednesday, but I'm not gonna be here. Is there any-
Who's, is Mr. Milano the attorney? Okay. All right, hold on a minute. So, Mr. Milano,
Got a couple I got an MDOC with you, we doing that?
hold on, you're gonna do Wilson, right?
Yes.
So in the matter of the people of the state of Michigan versus Frederick Dwayne Wilson, file number 23-21557FH. Mr. Wilson is not present. We did a writ. I'm assuming the prosecutor did a writ for them to appear in person. And we adjourned for sentencing on January 12, and he still didn't appear. So the prosecutor was supposed to do a writ for today. Plus, we don't have fingerprints, which is why I did the dang writ, so we could bring him here and fingerprint him. I fail to understand how a prisoner commits offense in prison in the Michigan State Police can't go to the prison and fingerprint them when their office is at the prison. Right? Does anybody not under? Yeah. Okay. So anyway, he's not here.
All right,
So why don't, Miss Adams, can I have a sentencing date about a month out in person?
Okay. March 8th at 8:15.
So we're gonna set it over to March 8th at 8:15. The prosecutor needs to do the writ. And we'll need him in person to get him fingerprinted, so.
Okay.
Okay, so that'll be, okay, so that takes care of him. And then I don't know where Mr. Jagger Margosian is. I know Mr. Williams is present in the building, so. All right, I'm gonna put the courtroom in the waiting room, so All right, this is in the matter of the people of the state of Michigan versus Jeremy Sneed, file number 23-21384FH. After a bench conference with Salvatore Malaro from the Public Defender's Office and Dave McCready from the Prosecutor's Office, due to the Sneed trial being behind a trial that takes precedence, we need to move the Jeremy Sneed trial. And we're going to just briefly move it. So I have set the trial date from March 6th of 2024 at 10:30 in the morning. He is set for pretrial tomorrow morning or next Wednesday morning. I set jury instruction voir dire deadline to be provided to the court by February 28th and motion deadline for the pretrial next Wednesday. Anything else we need to address on the record on this?
Not for the people. No, Your Honor.
All right, very good. Thank you both.
Thank you.
Michael can't zoom in. He required his client come in person. Michael, and Michael's gonna come over here in person.
I'm gonna be next door if you need me, Judge, and I'm downstairs.
All right.
Tear my hair out, what's left to do. Thank you very much, Judge.
You too. Bye.
Everyone have a good weekend.
You too.
You too.
Even you, Mrs. Fate.
Thank you. You too, Mr. Valero.
Every day is a good day for Miss Fade.
Yes, yes.
Mr. Dagger Margosian, your client's here. Are you coming over to meet with them?
I wasn't planning on it. I'm pretty under the weather right now. I didn't really want to pass anything along.
Okay.
But
Okay.
I'm happy to like coordinate somehow. I'm sorry.
Well, he's just here in person, so I expected you to be too.
Yeah, I'm sorry.
Okay, do you want him brought down?
Yes, please.
Okay. All right. Mr. Sneed, I don't have anybody here to speak. Is that correct?
That's correct, Your Honor. I believe there was a written victim's impact statement submitted.
Yeah, I reviewed that. Okay. So it's going to be a few minutes before he's brought down.
Okay,
So
thank you.
we're going to take a brief recess. that it? Okay. All right, and you just step up to that podium, okay? So this is in the matter of the people of the state of Michigan versus D'Angelo Monte Williams, file number 23-21309FH. I have Michael Dagger Margosian appearing on behalf of Mr. Williams. Mr. Williams had asked to be brought in person, and we did have him brought over today. I'm sorry, Mr. Sneed. I also have Isaac Sneed appearing on behalf of the people. And I have Jennifer Walsh, who prepared the pre-sentence report from the Michigan Department of Corrections. So, Mr. Williams, did you get a copy of the pre-sentence report?
Yes.
Did you get an opportunity to read through it?
Yes, ma'am.
Do you understand everything in this report?
Yes.
Do you have any questions about anything in this report?
No.
Did you have an opportunity to talk about it with Mr. Dagger Margosian?
No.
No? Did he come over and talk to you?
No.
Did he Zoom in with you?
When I got the PSI?
Yeah.
No.
All right, so Mr. Dagger Margosian, have you not met with him yet or been able
No.
to?
I haven't been, Your Honor, I planned on being there this morning. A few days ago, I got the flu. I'm apologize,
Yeah.
but I had every intention to be over there. So, obviously, I would like to speak with Mr. Williams a little bit. I know it's.
So he's in custody, so I can't do that. But what I can do, because he's scheduled for a trial in our next jury panel, I can set the sentencing over. There's the flu going around really bad, and we don't want anybody at the jail getting it, because if it comes to the jail, everybody's got it. So how about this? How about I set this over a week or two, so Mr. Dagger Margosian can sit down and meet with you?
Okay.
All right, Miss Adams, could I get another date from Mr. Williams?
I believe you have the book, Judge.
Well, why would you entrust me with that? Okay. Let me see what I got. So, no. Trial. So, Mr. Dagger Margosian, I could do February 16 in the morning.
I think that's
or
fine.
During the day that day, only because I have a jury trial and it's scheduled for 4 days, but I don't really, oh, no, I can't do that day. Never mind. Okay. 1 hour meeting. Okay. And then I have jury trial. Corey Reese. Didn't Corey Reese plead the other day, Becky? No. Okay, so I don't think so.
Your Honor.
I could, yes, sir.
Alternatively, I'm scheduled to be over in court this afternoon with Mr. Sneed. I don't know if we would want to set it that way. I think Mr. Sneed and I are going to try to talk about that case. It's not in this court, but that would be an option as well. Or if the court wants to just adjourn it, that's okay with me as well.
Well, I have a 1 hour hearing at 1:30 and then a 2 hour hearing at 2:30. So it doesn't look like I can. So I can do 8:15 on February. No, motion. Let me see. Motion to withdraw the plea. Bunch of sentencings, a BOP hearing. Sentencings. I could do February 23rd at 8:15.
That's fine with me, Your Honor.
Mr. Seen.
That works, Judge. Thank you.
All right. So, Mr. Williams, I'm going to set this over to February 23rd at 8:15 in the morning. So that's let's see, today's 9th, so 2 weeks from now. Okay, and then Mr. Dagger Margosian will meet with you and we'll be ready to go on that day.
Okay.
All right, so you're all set. Thank you.
Hope you feel better, Michael.
I know. Thank you, Jen.
Jeez.
I'll get there. All right, sorry, D'Angelo. We'll talk next time, okay?
All right. Thank you.